It says it's streaming live.
I got that message too.
Me too.
Okay, we are good.
Okay, I'd like to call to order. Please stand for the Pledge of Allegiance. Marty Tarr will lead it.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated.
Thank you, Marty. For the record, are all the Board of Election members here? Marty Tarr,
Present.
Kay Sullivan.
Present.
I'd like to have a motion to adopt the agenda as written. Does anybody?
I make a motion to adopt the agenda as written.
Anybody second it?
I second it.
Okay. Mr. Davis, are you present and ready to proceed?
I am.
Mr. Finger, are you here to represent Mr. Moskowitz?
I am.
Ashley Hudson, Town Clerk, can you confirm for the record this meeting was posted?
This was posted on September 4th at 3:45 p.m.
Town Council Fred Townsend, I'll ask you to read the rules of procedure.
Thank you, Ms. Bowl. The Board of Elections is authorized to hear and decide complaints such as this pursuant to 15 Delaware Code Section 7552. Today's hearing is a quasi-judicial hearing in which the qualifications of a candidate for commissioner are challenged. Candidate qualifications are established by the state code, town charter, and town code, and when called for by case law interpreting those statutes or similar statutes. All parties and those who testify will be asked to identify themselves and supply their address and pause to allow themselves to be sworn by counsel. First, the complainant will be called on to present his challenge to the qualifications of the subject candidate. However, neither the challenger nor candidate nor the general public may direct questions to one another, conduct cross-examination, or question the board. All testimony and comments are to be directed to the board. Each party may have 10 minutes to present argument. There will be no rebuttal or extensions of time unless so desired by the board. Following the testimony of the parties, each member of the public wishing to speak will be limited to 3 minutes. Additionally, and importantly, the subject of all testimony shall be confined to the issues relating to candidate qualifications. Those who testify are urged to restrict their comments to relevant issues and avoid matters of personal dispute and animus, as the Board of Elections is not authorized to resolve those matters. As we all know, this hearing is being conducted only weeks before an election. Statements of a political nature shall be deemed by the board to be out of order and disregarded. At the conclusion of the hearing, the board will deliberate publicly and render a decision in the form of an oral motion. In accordance with Section 7553 of the State Election Code, the board will issue a written decision within 24 hours, and that decision will be posted on our website. The parties may consult the state code for post-hearing relief if desired. Couple additional things. One of which is that by now many of you, if not all of you, have participated in virtual meetings. So it's going to be really important that we only speak once at a time and upon being recognized by our chairwoman, Elaine Bowl. If you wish to be recognized, you can raise your finger, but we're going to attempt to stay along or stay as outlined in the rules of procedure in terms of the presentation. One preliminary matter I have, which I attempted to bring to the attention of the parties this afternoon, is something that we confirmed only this morning at the law library in Kent County, where the Delaware laws are published and bound. And that is that we've done some research into the legislative history around our charter, and we found something very interesting. And it has, in my view, a bearing on the outcome of these proceedings, or a strong potential bearing on the outcome of these proceedings. Our charter in Dewey was originally adopted in 1981. And it's published in the session laws under Chapter 59 excuse me, of volume 63. So what we were attempting to do is just confirm that when we go to the state's website and publish our charter, that it is an accurate reflection of the legislative history of the act. And secondly, to be honest, there was some desire to confirm that language in the charter that could be read to suggest that residents have to be landowners or have an interest in property that's significant, was rightfully in there, in the face of some well-known case law issued by the Supreme Court and also by our Chancery Court on the subject. And we found something very interesting, and I'm going to share it with the public and with the board and the parties now. And that is that after 1981, our charter was amended with respect to section 5, which is a critical section here, on 2 occasions. The first was in 2008, and that amendment did not do, was not relevant to these proceedings. But in 2012, there was an amendment which did relate to our subsection C. So the subsection C of section 5 of our charter reads that other commissioners must, well, I guess I'll go back a little. I'll read the entire section 5 as it was originally adopted, or at least I'll read A, B, and C. Each commissioner shall be at least 21 years of age, a non-delinquent taxable of the county. That language is subsequently struck. And shall be non-delinquent as to all taxes levied or assessments paid to the town. That language was struck subsequently. Not less than 2 of the commissioners shall be designated resident commissioners. A resident commissioner shall have the following qualifications. He shall be a bona fide resident and domiciliary of the town. 2, he shall own real estate, or I should say, and 2, shall own real estate within the town or be a leaseholder of real estate in the town under a lease of a term of 5 years or more. And subsection C, other commissioners, that's other than resident commissioners, must have either the qualifications of a resident commissioner as defined above, which again would be residence and land ownership of some sort, as defined above, within the town, we're a leaseholder, as I said, 5 years or more, or be a full-time resident and domiciliary of the town. So in 2012, so I should say about that language that it seems to suggest quite clearly that you can be a qualified candidate and hold office as a commissioner by virtue of simply being a full-time resident and domiciliary of the town. In 2012, there was an amendment to subsection C of section 5, and it purported to insert language by a method that became popular or used in 2010 or so, which was not to strike language altogether and substitute new provisions. Instead, it was to print the old or the existing law and then show strikeouts of language to be struck and underlined language to be inserted. And that language or that section C does not reflect the existence of the phrase I just read to you, or be a full-time resident and domiciliary of the town. That language was not struck by the 2012 amendment, and it was not struck by any amendment since then. And consequently, I am forced to give my interpretation to my client in reading this, that the law of the town of Dewey is that a candidate may qualify as one by virtue of being a full-time resident and domiciliary of the town without regard to ownership of land or an interest in the form of a long-term lease. So that's a mouthful, I know, and it's a very unusual situation. Usually we're not arguing about the law. The law has been quoted to us, but the law as quoted to us by the parties does not include that term. And I think it's an inescapable conclusion that that language still remains the law, because the omission of that language, which is clearly some kind of an error on the part of the scrivener at the General Assembly, does not reflect, or the 2012 amendment does not reflect in any way the General Assembly's legislative intent to strike that provision. So while the parties have not received much in the way of notice to this, it has been shared with them, it is posted, and I wanted to invite the parties to speak to this question when they are heard from. So unless there are any preliminary questions, I'll end my statement and turn it back over to our chairwoman.
Okay, Mr. Davis, are you ready to proceed?
I am.
Okay, you'll be sworn in for the record. Please identify yourself and give your address and allow our attorney to swear you in.
My name is David M. Davis. I go by Dave. I own property on Swede Street in Dewey Beach, 16 Swedes number 3 or 18 Swedes Unit B, depending on which way you look at it. That's it.
Mr. Davis, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you may proceed.
Very good. Well, first of all, thanks to the board and the folks who are attending today. I'm here on behalf of the town's best interest to bring to light some things that I've found troubling, and I think the town needs to address them. As a property owner, we all live and want free and fair elections. And I think there's a situation here that needed to be brought forward, and so I've done so. This complaint is based on Mr. Moskowitz's qualification to run as a commissioner in this upcoming election. Let me address your comment first, if I may, Mr. Townsend. This was brought to my attention this afternoon, and my only comment at this moment can be, of course, as I'm not a lawyer and I'm not represented by a lawyer here, but I think I can fairly comment that any change that was made to the charter in the intervening years between 1981 and 2020 may be the case. I don't know what happened. I only know that everyone that I'm aware of in the town relies on the current copy of the code as published. And I rely on that. If that changes, then I think we have a different issue on our hands, and that needs to be addressed in a different venue than this. But that's my understanding. I go by the current code and charter language that's in there. And that's sufficient for today's purposes, I believe.
Well, Mr. Davis, I would suggest that the current charter includes that provision. So if you wish to argue otherwise, you may. Otherwise, you can proceed with your presentation.
I read the code extensively this week, and it was not present, so we can agree to disagree, Mr. Townsend. You know, I'm not represented by a lawyer. I conferred with some friends who've helped me do some of the research and understand, you know, some of the language that needs to be provided. Obviously, I did not write the complaint entirely by myself. It's not in a language that I would normally write in because I'm not a lawyer. But what I really care about is understanding that there are two qualifications in the town charter to be a resident commissioner. One is residency, and the other is property ownership. With property ownership, it could be accomplished a couple of ways: a valid lease, a registered trust, or a deed, and so forth. As late as a couple of hours ago, I received a lease that was sent to me by Mr. Finger, and I confirmed that that lease was not in force when the application was filed. It was not provided. as part of the filing. Excuse me, I have to turn my phone off. And so I'd like to call at this moment Kate Benezak as a witness to that effect and ask her a single direct question to accomplish that goal.
Okay, so who is Kate Benezak?
She's the town clerk.
Okay,
Well, not the clerk. She's, what's her official title?
okay, I understand. Okay, I know who she is. I'm sorry, I did not catch the name. So what is it that she can establish with her testimony?
That with Mr. Moskowitz's application filed in town hall, and she was the signer and the stamper on that application, there was no lease provided at the time, which is called for if someone is registering as a leaseholder.
Okay, so Mr. Finger, do you agree that that lease was not provided at the time the application was submitted?
Oh, well, I will, in my presentation, I asked that Mr. Moskowitz be put on the stand. But as a preview of what he will say is that Mr. Moskowitz spoke to you and asked him about the lease and was given the indication he did not need to present it.
Oh, okay.
I know it puts you in an awkward position because as a lawyer, you're not supposed to testify, but for my client, I'm willing to waive that.
Well, I fail to see the significance of the testimony of Ms. Benezak in that I think it's understood that the lease was not provided at that time. Mr. Moskowitz filed as a resident, not as a non-resident. Isn't that the case, Mr. Finger?
Yes, he did file as a resident.
So I think the record is clear that he filed as a resident and he did not feel compelled, nor was he required to file any support for that other than that which he did, which did not include a lease, correct?
That's correct.
I mean, isn't that an established point? I mean, do we need testimony to establish that the lease wasn't provided?
No, I don't believe so.
I don't believe that we do. Mr. Davis, I think that that's a fact that the board can accept, that there was no lease provided at the time of the submission of the application. The legal significance of that, I think, is up for debate, and we'll hear from both sides on that. But I don't think we need to hear a witness to that effect.
Okay, I can provide a written email exchange that shows her answer to that question in any event.
I don't think that's necessary. I think that the board can accept that the application did not include a lease. I think that's.
We can accept that. I actually was in the office when you had called, Mr. Davis, and that is absolutely true. There was no lease attached to the application.
Then I'll leave the question of why it was supplied, but let's move on. I believe the argument for Mr. Moskowitz's candidacy hinges on his ownership of property within the town. And as you saw in the complaint that I filed on June 3rd, I believe the date was, he transferred via deed, which is registered at the Register of Deeds, his property to, I think it's beachtime.com LLC. And by virtue of that, and the fact that an LLC owns that property and did so as of the date of his filing, that he does not own property in Dewey Beach that we could find and I'm aware of. If there's other property that he owns personally in Dewey Beach, it was not surfaced in a search that we did of any property records at the deed office.
Mr. Davis, you represented that the argument that you're making hinges on whether Mr. Moskowitz owns real estate within the town of Dewey Beach.
Personally.
Right. But now I have presented to you the 1981 lease, made references and supplied you with the 2012 amendment to, charter And I've supplied you with a copy of the 2012 amendment to the charter, and it purports to indicate that it is not required that you be a property owner in order to run for office within the town of Dewey Beach. You don't accept that.
I don't accept it in this venue. I think that has to be argued in another venue and can't be handled by a citizens board such as this. That's
And you
something
think,
that have to be done also today.
do you also think that's an appropriate, there's an appropriate public policy which justifies requiring resident candidates to be property owners or owners of long-term leases rather than be viable candidates by virtue of being a resident and domicile of the town?
I do, and or a registered trust document, which he has not done either, to our knowledge, and I'll get to that in a moment. So if I can proceed.
Please do.
A member of an LLC is not an owner of the property held by the LLC. That's been pretty clearly established. And at this point, I think that there's some argument that I'd expect to hear. I don't mean to preface Mr. Finger's arguments here, but I think I should address the things that we've thought of that he might try to bring to light. And that is, in the conveyance on the deed, says to beachtime.com LLC by David E. Moskowitz, sole member, if I got that correct. The word by stipulates something. I don't know what it means. It certainly doesn't mean and therefore he could not be construed as a co-owner of that property. I don't know what that phraseology means. If he was attempting to show co-ownership of the property with the LLC, he would have to have had something in there about joint tenants, as I understand the law. There is nothing to that effect in the title that was assigned. And even if it were, by doing that, it kind of defeats the whole purpose about putting a property into an LLC, I believe, by shielding your liability, which is the whole idea of putting a property into an LLC. If he named himself as co-owner of the property, he would be reopening himself to liability, which of course is, senseless. So for those reasons, I don't believe that there's any case to be made for him being considered a co-owner of the property with the LLC. And therefore, and in the state's opinion, the property is owned by the LLC beachtime.com LLC solely. Any questions about that?
No, that's consistent with the advice that I plan to give.
Okay.
The
In the Cape Gazette article that referenced this hearing, came out, I believe, yesterday. Near the end of that article, Mr. Moskowitz made a claim that he had conveyed the property to an LLC and wrapped it in a trust. In a search at the Recorder of Deeds, we were able to find no documentation of a registered deed to that effect by a trust, only the LLC itself. So we submit that there's no basis for that claim to have any value or merit.
Excuse me, I just would like to let you know you have been speaking and I've stopped for Fred and myself, but I just wanted to make sure you knew that you have been speaking for 6 minutes and 24 seconds. You still have 4 minutes to go.
Right. Thank you. Let me back up a step. My only thought and the reason that I'm here is to make sure that the rules are followed correctly. And so I'm asking you to consider Mr. Moskowitz's qualifications to be a candidate for election. The notion that a person can change their argument to this, which we've seen several times in the last 24 hours. At first it was, I own the property. Then it was, it's owned in a trust. Then it was, there's a legal argument as to the charter. And now latest is there's a valid lease, which we've all agreed is not valid for this purpose. That's a meandering argument. So I just want the truth to be told here. I want Mr. Moskowitz to be either judged as a legitimate candidate or an ineligible candidate based on the facts of the situation and the legal documents that are available. And I'd like the opportunity, if I may, to also comment in response to anything that's brought up later. Mr. Finger will have that opportunity to do. I'm asking the board to grant me a chance to make commentary further down the line in the hearing. Thank you.
Mr. Davis, what box on the candidate filing form should Mr. Moskowitz have checked, in your opinion?
Well, I guess there are only two choices that I'm aware of on the filing form. One is resident and one is non-resident. And if he does not fulfill one or more of the qualifications as resident, then he would have had to check the other.
So it's your position that the word resident commissioner or the words resident commissioner as they appear there are terms of art, not to be confused with the common meaning of the term resident.
Can't speak to that as a non-lawyer. What I can say is that the way the charter is worded in that regard requires one of those requirements to qualify as a resident candidate, which is, as I recall just briefly, and I can't cite it exactly, it's either to own property or have a valid and registered trust or have a valid and presented lease on the property.
So, Mr. Davis, do you concede that Mr. Moskowitz is in fact a resident of the town of Dewey Beach?
To the best of my knowledge, he is, but I have no firsthand knowledge of that.
So it's not your view that you have a duty to prove that he's not a resident of the town of Dewey Beach in order for this board to uphold your complaint?
Can you say that again?
Yeah, so you don't view it as your responsibility to persuade this board to view Mr. Moskowitz as a non-resident or you don't feel you have to persuade this board to believe that Mr. Moskowitz does not reside in Dewey Beach in order to win your complaint?
Well, what I think I can say safely is that if a person's a resident, they wouldn't need to sign a lease. But apparently Mr. Moskowitz did sign a lease, which I guess depends on your definition of resident. So with that, I'd say that's about the only comment I can make, Mr. Townsend.
So you think that in order to be a resident of the town, you have to have a signed lease if you don't own property in that town?
I don't know if I could think of another situation that would qualify, but
well,
I can say.
Suppose you're an adult child living with your parents. Suppose you're a 40-year-old living with your parents in the town of Dewey Beach. You would not expect that resident of Dewey Beach to have a signed lease, would you?
No, I think that's a legitimate question, but that's not the case here with Mr. Moskowitz, is it?
It's not, but the consequence of your contention here is that that individual cannot qualify as a candidate for the town of Dewey Beach.
Well, there are only two boxes to be checked on the candidate form, resident or non-resident. Presenting my case that he doesn't qualify as a resident, cannot comment on the other status. Maybe there should be other statuses added to the form. I can't comment on that. I'm not a legal mind, but in my view and with all the information that I've gathered, I believe, and it's pretty clear, he is not qualified as a resident.
Well, the candidates running for office, and you may have been one at one time, don't prepare these candidate filing forms, right? The town does. Isn't that correct?
As far as I know, yes.
Okay, Ms. Bohl, if you have any questions or want to invite your members to ask questions of Mr. Davis.
Are you finished, Mr. Davis?
I am, but I do request that I be able to respond if I find something that deserves comment, please.
Mr. Townsend, is that part of the rule?
We're going to move on. The rules we've adopted don't include any rebuttal following the initial presentation. The board, you can ask, and the board may choose to allow it, but we'll see where we go from here.
Okay, you still have 2 minutes left, but back and forth, at this point, I just want to see if, Ms. Tar, do you have any questions?
Not at this time.
Okay, we may come back with some questions for you, but Ms. Sullivan, do you have any questions?
Not at this time.
Okay, thank you very much for your testimony, Mr. Davis, and we will possibly be back to you if we have any questions. Thank you. Now, Mr. Townsend, are you going to be speaking with Mr. Fink?
Mr. Finger? Mr. Finger, I think the floor is his. He's a member of the bar and not required to swear an oath.
And thank you very much, and I thank the board for allowing me to appear before it. Mr. Moskowitz submitted a candidate form which he said he was seeking election as a resident commissioner. That's the box he chose, and that's what he wants to be. He did not provide his lease at the time. Nothing on the form requires it, and unless I missed something, nothing in the charter requires it either. Presumably, it's only intended in cases where there are challenges like there are now, and then it has to be produced. Mr. Moskowitz is not a stranger to Dewey Beach. He's served as a commissioner. He's lived here for a number of years. There is nothing in Mr. Davis' challenge letter, indicating that he is challenging Mr. Moskowitz's residency in Dewey. And therefore, I respectfully submit that that issue is waived because you have to give advance notice of what your grounds are so that the other side can prepare a defense. However, Mr. Moskowitz is certainly willing to testify if the board desires it about his history in Dewey Beach. So that brings us to the other issue of the requirements, and that is residency, not residency, but property ownership.
Mr. Finger, can I interrupt 1 second?
Of course, sir.
As to one of the contentions you just made, I will point out that Section 5C says for those people who are applying as leaseholder candidates, a leaseholder candidate shall be required to include a copy of a valid lease with his or her candidate filing. So if you check the box leaseholder,
A resident.
if you consider yourself a leaseholder resident, you've got to file a copy of the lease.
That's fine. Then I leave it to the board's discretion as to whether that absence is a mandatory disqualification. I suggest it's not, but be that as it may, there was no complaint from the board, certainly, when they received his nomination for. But even so, there's a couple of things that need to be addressed. The question, does he own property? And Mr. Davis says he doesn't. A limited liability company owns it, and that's true. It's also true that Mr. Moskowitz owns that limited liability company, and he's the sole owner. Now, there are two types of ownership in the law. One is direct ownership, which would be if Mr. Moskowitz's name was on the deed. But there's also a concept of indirect ownership, where there's an intermediary that ultimately leads back to you. So Mr. Moskowitz owns the LLC, which owns the property. So he is an indirect owner. And again, the charter does not distinguish between the two. And there may be a legitimate legal question as to whether indirect ownership is or is not on a par with direct ownership. However, it is certainly something that is subject to a judicial determination. But I want to go beyond that. I don't believe this this board needs to even address that issue because of the law. I provided to Mr. Townsend earlier two cases which he referenced today. One is a decision of the United States Supreme Court called Turner versus Fuchs. It was decided in 1970, where you had to be a property owner in this town to be a jury commissioner or on the Board of Education. And in that case, the Supreme Court said to distinguish between property owners and non-property owners violates the constitutional requirement of equal protection under the law. There was not considered to be a rational relationship between property owners and non-property owners in terms of the service they can provide. And so that fact, or that conclusion, pretty much wiped out the ability to distinguish between the two. And then a couple of years later, our Court of Chancery had a case before it. It was called Geblein versus Nashold, who was the mayor of the town of Frederica. And again, a citizen who wanted to be up for election for an office was disqualified because it required him to be a landowner. And the Delaware Court of Chancery followed and in fact cited the Fuchs case I mentioned to you and said, this says we cannot distinguish between landowners and non-landowners. And that, so that is pretty much the legal encumbrance we now find ourselves with. We must abide by the law. And Mr. Townsend will probably offline discuss that with you. So I'm not going to make a lot of hay about it, but it is a very significant point because, by the way, and these two cases are not unique. There are about 5 or 6 other federal courts that have said the same thing. So if this were a matter to get before a judge, it would be pretty much open and shut case. Therefore, there are issues before the board as to whether ownership requires direct or indirect ownership. And there is a bigger issue about whether ownership requirement can survive a constitutional challenge. And for this reason, we think that for that second reason, this board need not even address the first issue. With that, how much time do I have left?
You have about 5 minutes.
Thank you very much.
Mr. Finger, could
Yes.
you also include a comment, if you would, in response to Mr. Davis's comment that this is a citizens group that is not qualified or not bound by the Supreme Court holding and the holding in the Geblein case by our Court of Chancery?
Well, I believe this group is created by the charter. And you said in your introduction correctly, it's a quasi-judicial body. It's going to make factual determinations. And, I don't believe there's anything impeding you, this board, from accepting that a legal determination is provided by counsel. I am raising this point to say that it would be better for this board to recognize the constitutional limits than to have to take it to a judge to do it. So this idea of citizens board, I don't really know what that means legally. I mean, I understand his conception. All boards are citizens board because they're made up by citizens, but that does not change its governmental nature. If it was a purely citizens board, it would not be a quasi-adjudicatory board. It would just be, it would not even have any meaning, because a purely non-governmental entity could say something all they want, but it has no bearing. The strength and the power of this board is by the nature of the fact that it is a governmentally created and permitted entity. So with that, I would like to ask Mr. Moskowitz to be sworn in to answer a few questions.
Mr. Moskowitz, your name for the record and address.
David Eric Moskowitz, 25 Reed Avenue, Unit 7, Dewey Beach, Delaware, 19971.
Mr. Moskowitz, do you solemnly swear or affirm the testimony given this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Moskowitz, where do you live? Oh, you gave your address. How long have you lived there?
I bought my property in 2013.
Okay. And you recently sold it, correct?
Well, I placed my house into a sole member LLC, wrapped into the trust for liability and estate planning reason. I had gotten a false diagnosis of COVID, and I wanted to take care of for my daughter's benefit and make sure she was taken care of should something happen to me.
When you say it was wrapped into a trust, who's the trustee of that trust?
David E. Moskowitz.
Yeah. But the deed doesn't mention the trust, does it?
In my trust document, it basically puts beachtime.com LLC as one of the holdings.
Okay.
So that same day I did, based on advice of my lawyer, I did an LLC, a trust, and a lease.
So you did, you named your LLC as the owner of the property, and then you place the property into a trust in which you are a trustee, correct?
Correct.
Okay.
With the beneficiary being my daughter should something happen to me.
Where does your mail arrive?
My mail goes 25 Reed Avenue, Unit 7, Dewey Beach, Delaware.
Has it ever gone elsewhere since 2000, since the time you bought that house?
No, I've basically always got my mail here. I've lived here with I have a shared placement with my 17-month-old daughter. And I mean, she was born in BB and I've been raising her. She's only been outside Dewey Beach 2 days in her whole life.
And do you pay any taxes to Dewey Beach?
Well, Dewey Beach has no property tax, but I pay indirectly a beach tax, and then I file forms with the state of Delaware for taxation.
Okay. When you filed your candidate application form, did you include your lease?
I did not.
Why not?
Well, I had asked the solicitor what I needed, and when I filed with my application, and then I included also a copy of my driver's license, I believe an electricity bill and an internet bill, and then a police report showing that I was a subject of identity theft in case my driver's license got posted on the internet, to not repeat that experience.
So at this point, had you transferred the title to the deed to the LLC?
Yes.
Okay. Did you mention that to the solicitor?
I did.
And what response did he give you?
Well, he had just told me to file as it is, because when we did the charter change, it was a 2-year thing, and then they forgot to submit it. So the state would have already approved it. The charter change actually changed it because we were told like things of how things were done were not correct. So the new charter, which the state has currently in their possession, would basically correct it so that it flows based on the voter registration.
If I can interrupt, this business about the new charter is entirely irrelevant. I mean, the new charter is a proposal, and it is not law until such time as the General Assembly adopts it. I think it's common knowledge that this issue of residency is addressed and corrected in that document, but that document is not law and it's not relevant to this consideration.
I would like to just add one more thing, if I could. When Commissioner Persinger submitted his election paperwork, I believe it was deficient with a letter to the town manager, and they had actually contacted him to give him notice that it was missing something and let him hand it in.
Last question, Mr. Moskowitz. You served as a resident commissioner before, correct?
Yeah, I've been serving for the last 2 years as resident commissioner.
Thank you. I have no other questions.
If I may recoup either some of my 2 minutes or respond to 1 or 2 things.
Mr. Finger, are you done with your presentation?
I believe I am. Give me a moment to check my notes. Yes, I believe I am. Thank you.
Your time is up anyway, so thank you.
Okay, Mr. Davis.
Thanks. A couple of things that I heard Mr. Finger say. First, he questioned the need for the lease. I think it's pretty clearly stipulated in the requirements for a resident as one of the stipulations or one of the options.
Well, if I could correct you. That is a requirement for someone in the charter who declares that they are a leaseholder candidate.
There is no designation on the form to check as leaseholder candidate, but let it go as that.
That's right.
Also raised the issue of indirect ownership by virtue of members in an LLC owning real property. I think that's pretty well settled law and not the case. The trust that Mr. Moskowitz refers to is no doubt there somewhere, but it has not been registered as is required. It's one of the requirements of the filing. So he's not a property holder through the LLC. He's not a property holder through the trust. He's not a property holder through the lease. I question where he is a property holder. And, I think it's important that if Mr. Finger is going to raise all these other related issues in case law originating in places as far afield as the Supreme Court here, that to me sounds like, he's avoiding the issues at hand, which is Mr. Moskowitz a property owner in Dewey Beach? And that's all I can say on the matter.
Okay, thank you, Mr. Davis. Fred?
Well, do the members have any questions for any of the witnesses?
Marty?
Not at this time.
Kay?
No.
I don't either.
Okay.
Should we open it up to the public?
Yes, that'd be fine.
Okay, Ashley?
If we could remind the speakers that they're limited to 3 minutes and they're advised to restrict their comments to the issues that are relevant to the application.
Okay, that is extremely important. This isn't a political debate. This is a hearing, and we really, 3 minutes is a lot of time. So Ashley, is there anybody?
Yes, that'd be fine.
Okay, Ashley?
If we could remind the speakers that they're limited to 3 minutes and they're advised to restrict their comments to the issues that are relevant to the application.
Okay, that is extremely important. This isn't a political debate. This is a hearing, and we really, 3 minutes is a lot of time. So Ashley, is there anybody? We're getting, I don't know if anybody else has this problem, but I'm getting, it's not real time. It's.
Any advice from Ashley as to how to proceed? Does Ms. Shoup need to call in or?
He's here. So it looks like she's on YouTube as well. Lynn, can you hear us?
I can hear you. Can you hear me?
You can just
I can see you too.
Yay.
turn your YouTube on.
I hear should I turn my YouTube?
We're getting,
I'm trying to.
Anybody else has this problem, but I'm getting,
Please turn your volume down on your YouTube broadcast.
All right, so I turned the YouTube off. Am I on now?
Mhm.
All right, let me pull mine up. I'll be quick. So hi, my name is Lynn Shoup. I'm a resident of Dewey Beach. I'm also a licensed business owner here and a member of the Delaware and Maryland state bars. I've never done this before, but I chose to offer comments today because I've been following this election and the candidates, and I do have some serious concerns. So it's my legal opinion that Mr. Moskowitz is not qualified to continue his term as commissioner, nor run for re-election. Having transferred his real property interest into an LLC in May of 2020, he, as an individual, is no longer legally recognized as the owner of real property in the state of Delaware. While he may be a resident of the town of Dewey Beach, he's no longer a property owner here. The assertion that the deed creates some form of joint tenancy between the LLC and Mr. Moskowitz is patently absurd. I don't think this issue has even been discussed today, so I'm going to skip that whole paragraph. Let's see. The idea of indirect ownership is inapplicable in this situation, as the standard upheld for decades in the town is direct ownership. Furthermore, the case law invalidating the code provisions, the decisions of other courts, is also invalid in this decision because this board is not a court. It does not have the authority to strike a provision down or rely on precedent. The town must change the code or take it to court, but not this board. Do not be confused by Mr. Finger. You're required to follow the code at this time and the laws of the town. And per that code, Mr. Moskowitz is not entitled to run as a candidate. Let's see. It's my understanding the lease was procured today and that such lease meets the technical specs required of a potential candidate. However, it's also my understanding that the lease was not produced at the time of filing for candidacy. It was not notarized. It was not filed timely. It seems to have been hastily generated from an online form for the purposes of this hearing. It is inconsistent with the other documents that were signed on the day that his LLC was created. I question the validity of the lease. First, for failure of financial consideration. And as we all know in contract law, you have to have offer acceptance and consideration or some form of exchange of money. And second, as it seems to have been produced solely for the purpose of allowing the lessee to qualify for elective position. And as such, it would likely be viewed by Delaware court as fraudulent. Mr. Townsend, I am confused who you represent. In your opening statement, you called Mr. Moskowitz your client as a candidate. However, you represent the town and the commissioners. And to me, that seems like a conflict of interest.
Ms. Shoup, if I did not mean to refer to Mr. Moskowitz as my client. I certainly do not.
Yeah, I was shocked by that because you did in the first statement.
I misspoke. I'm
Okay.
clearly not his counselor.
Okay.
Excuse me, you only have 20 seconds.
Okay. The idea that a Hail Mary is being thrown asserting that the code is incorrect is a separate matter altogether. That's for the town to review and change, not to raise now and implore the elections board to rule upon. The board must act within their responsibilities and rule on the code as written. The idea that there's a verbal assertion of a loss provision is not recognizable by this board.
Thank you. Thank you very much. Ashley, is there anyone else?
It looks like Marcia Sheck. I'll bring her in now.
Okay. Hi, Marcia.
It's connecting to her audio now. Just one moment.
Okay. Ms. Sheck, are you there?
Sometimes it takes a bit of time for the audio to connect.
Okay.
She's connected now.
Ms. Sheck?
Yes.
Hello. You have 3 minutes and please start.
Okay, hold on. I'm gonna, I need to turn off YouTube. So give me a second. Yeah, I am.
Go ahead.
All right, give me a second. I'm just trying to get YouTube off.
All right.
Can you hear me okay?
Yes.
Okay, all right. I'd like to, yes. So give me a second, please.
The hour bell.
Give me a second. Can you hear me without an echo?
Yes.
Perfect. Okay. Thank you, Marcia Schick, 201 Carolina. It's really unclear how Mr. Moskowitz is filing. In the past 7 days, he's changed his form of filing 3 times. And in the 11th hour, he seemed to be filing as a non-resident leaseholder commissioner by the production of a lease at 2 o'clock this afternoon. Mr. Finger is focusing on a constitutional challenge that needs to be made in a different venue, in a different court. There is not a determination to be made here about whether there's a constitutional challenge that Mr. Moskowitz is bringing forward. That's not how it works. If he now has a claim that there's a constitutional issue, and this is about his constitutional beliefs, it's indicative of the fact that he didn't follow the rules, and he needs to take that up in another court. Mr. Moskowitz has the full burden of proof to show that he played by the rules that we have in place currently. The charter does allow for people that don't own property to run for office in the town. That's why you can run as a non-resident as a resident or non-resident with a lease. So the whole idea of the constitutional issue not allowing non-property owners to run is, in my opinion, moot and a whole different set of circumstances, because we do allow non-property owners to run. That's how he's running with his lease. Mr. Moskowitz basically did not follow the rules. Now he's claiming differently. He broke the rules as a non-property owner filing when he didn't submit the lease. It has nothing to do with the constitutional issues because the charter allows him to run that way. The decision here really needs to be predicated on the charter we have in place today. Those rules are what govern the town, this board, and elections at this time. If there's a claim that the charter is not correct, then there are specific processes in place that must be followed that are articulated by state and local statute. It requires FOIA noticing, public hearings, an ordinance to be presented and voted on by the commissioners. If approved, that would be sent to the state for a final approval, upon which time the charter can be changed. The board does not have authority to change the rules in this venue, as it would divert the legally required process that must be followed.
Marcia, you have about 15 seconds.
Okay, if this board accepts Mr. Townsend's request to essentially authorize them to change the charter, they would do so in direct violation of the rules that govern this state and locality. You will also open yourself to exposure of liability because you will set a very dangerous precedent.
Okay, thank you.
If I could just respond, not to Ms. Scheck, but to the board. I am not proposing or arguing that we should be changing the charter or adopting any kind of an interpretation that changes the charter. It's quite the contrary. I am indicating that the charter is not changed, and the charter as it stands does allow for candidates to run by virtue of being full-time residents and domiciliaries of the town without regard to property ownership. But if we could move ahead.
Okay, it looks like Karen Kruger is the next person. Is that right, Ashley?
Correct.
The charter.
Okay, Ms. Kruger, are you there?
I am here, but I'm hearing Mr. Townsend's comments overlapping mine.
Does allow.
That's because you have
silence
YouTube,
your
I think.
YouTube to run by virtue of being
You have to turn it off.
Yeah.
domiciliaries of the town without
Let me just-
regard to
sorry.
property ownership.
Let me figure out how to do that.
Move ahead.
Okay, it looks like Karen Kruger is the next person. Is that right, Ashley?
Interpretation
Correct.
of the charter.
Karen, are you there?
Yes, am I in the Zoom venue?
You're in the Zoom and you have 3 minutes. I'll let you know about 10, we have about 10 seconds left, okay?
Okay, thank you so much. Good afternoon. My name is Karen Kruger. I'm a member of the Maryland Bar and also a property owner in Dewey Beach. And I'm commenting to echo those comments made by Ms. Schoof and Ms. Shake, who were very articulate in addressing both the factual issues. Well, there really isn't a factual dispute here, but the legal issues, including the constitutionality question that was raised by Mr. Finger. Ms. Scheck properly points out that there are provisions for non-residents and for non-property owners to also run for office in Dewey Beach, and that renders this charter provision to be constitutional in my view. And the thing that we have here really is a change of what your legal advisor contends is what the charter is supposed to say, which it doesn't say, at least not in the versions presented on the town website. When I go online to do legal research and I look for the charter for the town of Dewey Beach, the provisions that are present are that if someone wants to run as a resident commissioner or for that office, it is a particular term of art under the charter and is defined within the charter as someone who is a resident, who owns property or property in trust, or who has signed a 5-year lease, and that paper is filed with the candidate's initial registration. Mr. Townsend now tells us that the legislative history says, oh no, there should be something else in there, and it should be, or can just be a resident or domiciliary. Well, but that's not the information that was made available to the public and to the candidates at the time that candidate filing was opened. So what your board must follow is what the citizens' expectations and the candidates' expectations were of the rules at the time of filing. And that's clear. You have before you plenty of information that shows what those requirements were. Those were the requirements at the time. As Ms. Scheck points out, it can't just be changed due to the advice of legal counsel. There has to actually be the proper correction made in the proper forums. I thank the board for this opportunity to speak, and I know you will reach a fair decision. Thank you.
You're welcome. Ashley, is there anyone else?
And Jill Campello,
Okay. Jill, are you there?
not quite yet.
Okay. Ms. Capello? Can you hear me? We can't hear. I think you might be on mute. You're on mute. There we go. Okay. Here we go.
Thank the board for this opportunity
Okay,
to
I'm
speak.
just
And I know
shutting
you.
One second, Jill. I just want to start. We couldn't hear you at first.
Yes.
Okay, so. Okay, go right ahead. I'm sorry.
Okay, sorry. So I'm sure that what I'm going to say is repetitive, and I have to say that I did think that Mr. Townsend was trying to say that we should be following a different charter, but we're not, and he clarified that. And the charter is the charter that's existing. We know that it has mistakes in it and things that need to be corrected, and there's a procedure to do that. The other thing that I feel that he clarified is that this is not a constitutional issue for this board to decide on, and that Dewey does allow or people who do not own property to run and to vote. So for me, what's most important about this when you consider someone who's running for commissioner is that they fill out the proper paperwork and follow the charter as it's laid out. And there are many opportunities to register following one of the venues that the town provides. And one of the things that I have found very confusing about this is that there was one news report where Mr. Moskowitz said that he had been a property owner for 7 years and he was a property owner. And the next news report, he said that the trust was, or the deed was wrapped around a trust. And then he said that his advice came from Mr. Townsend. So it changes. But when you look at the documents that he filed online, it's pretty simple. He wrote down that he was running for re-election and used his address and did not give any indication that he was no longer a property owner, that he had put his property into an LLC, or that he had a lease. And so no one would ask him for other information because he didn't give let anybody know that anything had changed. And so when you sign that paper, you are signing that the information you are giving is correct and accurate. And so based on that information, that's where all the issues have come, because the deed that is filed with Sussex County is listed as an LLC. And there is no trust to be found that is registered with Sussex County. And if there was a lease that should have been considered, it should have been handed in. And that's per the charter, which is pretty simple. And so for the reason that he did not file correctly, that's the issue here. He did not file correctly. And that's basically all I wanted to share, except thank you all for giving your time to this. And, I'm sure that it could have been accidental. I believe that it might have been, but the fact is it wasn't done correctly.
Okay, thank you.
Mm-hmm.
Ashley, is there anyone else?
There's someone who is listed as iPhone.
I couldn't hear you.
It says iPhone.
Steve Spence, perhaps?
Looks like it's Mr. Spence, yes. He's connecting to audio right now.
We can't hear you, and
Well, it looks like it's still trying to connect to his audio.
mhm,
Can you hear me now?
There he is.
yes.
There we
Okay,
go. Thank you, everybody.
could you please give us your name and your address?
Yes, my name is Stephen Spence. I'm a Delaware admitted member of the Delaware Supreme Court, and I represent several property owners in the town of Dewey Beach, including Alexander Pires, John Snow, Eric Schweiderlich, and I was asked to prepare a brief memorandum, which I submitted earlier today and appeared on the website sometime this afternoon. And I had some nominal additional comments.
All right, Mr. Spence, you have 3 minutes.
Thank you. I'm not going to try to repeat all the other things that were said by others. I wasn't aware of the alleged problem with the charter until I got on, and I missed the very beginning of the discussion because when I tried to get on the website, it didn't allow me in right away. But I've looked at the citation to statutory authority that's in the town code and has been in the town code for many years, since 2012. And I guess the argument is that some language that was in a code is deemed to still be in the code, even though it is not in the 78 Delaware Laws, Chapter 346, which restated, and it used the introductory statement about interlining and deleting, but the language about being able to vote just by virtue of being a resident is nowhere in that section and nowhere in the current version of the charter. And so I'm not sure I really understand the conclusion that council's reached. I think the General Assembly is presumed to have known what they're doing when they restate a section, and I just respectfully disagree with the town council about that. The second comment I was going to make is that I think the town council didn't agree with some of the statements that were being made by Mr. Moskowitz about what he asked about and what he was told he should do in connection with his application and his August 17th or 18th submission to be a candidate. But I don't think he can rely on the town's attorney for advice like that, number one. Number two, I think you as your group should measure his eligibility as of the date, which was no less than 30 days before the election, because that's what Section 9 of the Dewey Beach Code requires. And I think the events which occurred after that and the long and winded explanations that occurred after that are really irrelevant. I think if he was not an eligible candidate on the day that is no less than 30 days before the election, then he's just not an eligible candidate. So I don't think you should measure what he did or didn't do last week, today, or this afternoon. I think you should measure what he was required to do under the charter, both in Section 5 and 8. And I think I've explained that relatively well in the memo. There was no discussion about the alleged missing language, because I wasn't aware that that was an issue until I tuned in, and I realized there's probably no time to supplement that, but I respectfully disagree with council about the way that one should interpret the
You have
code
10 seconds.
and as enacted. Thank you very much, and hopefully you'll be able to make a decision.
May I ask a question of Mr. Spence?
Oh, Mr. Spence?
Yes.
The
Yes, I'm still
attorney
here.
has a question for you.
Mr. Spence, did your memo take into consideration the Gebline case and the constitutional law and issues related to the requirement that people who run for office who reside in a jurisdiction must also own property?
I did not address that, and partly because you can't tell what Mr. Moskowitz was claiming until 2 o'clock this afternoon. It's difficult to address matters when they're developing around you. So I did not address that. Had I known that he was claiming that it was unconstitutional, I would have addressed it.
Well, I don't know that Mr. Moskowitz, as you know, these proceedings are very much expedited and not on the papers. And I did not know before advising my client what arguments Mr. Moskowitz's counsel was going to make. I can tell you the issue of the constitutionality of statutory requirement someone be a landowner in addition to being a resident was something that had caught my attention, and I'm wondering if that does not trouble you.
Well, I think the town attempted to resolve that by providing for situations where if it's a longtime resident of the town, that they can qualify on that basis. I have not tried to compare that to the Gebelon case to see whether it would pass muster, and I'm not sure it's fair to ask this board to do that. I think the prior parties who commented made the right suggestion, which is read the charter, try to answer the question for yourself on the charter, and let the lawyers litigate the issue of constitutionality at some later time if it really needs to be litigated.
So if we read the charter the way that the complainant is asking us to, then residents of the town who don't own land or don't have a long-term lease may not qualify as candidates for office. That's the conclusion that you're asking us to reach.
I think that's what the code suggests, the charter suggests, and I think this particular board created by that charter should follow its charter.
Thank you, Mr. Spence.
Thank you.
Okay, is there anybody else online?
There's another person I'm bringing in. It just says iPhone as well.
Okay, I don't know who they are.
Sorry.
That was never mind. Sorry. That was still Steve Spence. It looks like David Jasinski is in the waiting room, but I'm not sure if he's just there as a commissioner. So I'm going to bring him in just to double check.
David, is there anybody else online?
There's another person I'm bringing in. It just says iPhone as well.
David, you need to turn off your YouTube.
That was never mind. Sorry.
Or put him on mute then, because he doesn't.
Hey, this is Dave Jasinski here.
Okay.
Can you guys hear me okay?
Yeah.
Okay. It's just the little lag there.
Introduce yourself, please, again, and where you live, and you have 3 minutes.
This is David Jasinski. I live on Chesapeake Street, and I'm speaking to you as an individual today. To Mr. Townsend's point, I do want to address the qualifications to hold office in Dewey Beach. When I heard of the challenge to Commissioner Moskowitz on a technicality, I read the applicable town charter section closely. I was surprised when I read it, as it could disenfranchise many Dewey Beach property owners. The charter requires those on leased land to have a term greater than 5 years. Most of the original leases in the entire northern half of town have less than 5 years remaining unless the leaseholder signed an expensive new lease or purchased their land. The language in the charter does not specify whether it is an initial term of 5 years or 5 years remaining. It's completely silent in this regard. The language in the existing charter, and I believe the pending charter, doesn't address which it is. Even if the language is clarified to, quote, initial term, that means someone could be eligible to run with just 1 month remaining, get elected, and then cause political mayhem. Since it seems like some people in town are willing to use a technical challenge on obscure points to try to unseat a sitting commissioner or prevent the election of one, it's imperative that the Board of Elections study this issue and issue a recommendation as soon as possible. It would be unfortunate to see some people emboldened by the current effort towards unseating Mr. Moskowitz to use that precedent to try to remove any candidate or commissioner who's on a lease that expires in 2024 or 2025 by claiming their lease term is less than 5 years. This has the potential to unfairly exclude large segments of Dewey's community from holding office. Supporting Mr. Davis's complaint has the potential to cause mayhem via vague challenges based on leasehold status. Thank you.
Thank you. Ashley, is there anyone else? There's no one else. Okay. I'd like to ask Fred if there is, if you could provide us with your deliberations about what we've heard.
Okay, so what I want to do is make myself available to answer questions. I will have a couple of comments before we begin. I don't know if any of the members have a question for me right now. At this point, we're not going to take any more testimony or offerings from the parties.
Can Mr. Jasinski hang up his connection?
So he's muted. Okay, so there has been a lot made of the issue of the production of a lease by Mr. Moskowitz. However, I would view that as evidence of his residency and not evidence of an intent to run as a leasehold candidate under the charter. He didn't check the box of he was given two options when he filed his application, either indicate that he's a resident or a non-resident. The complainant has not taken it upon himself, nor have any of the others to contest whether Mr. Moskowitz is in fact a resident. It seems to me that Mr. Davis had the burden to demonstrate that Mr. Moskowitz was not a resident, and he didn't do that. Now, Mr. Davis wouldn't accept that because he would say that the charter says you have to be a landowner. And I am here to say that what is published on the state website appears not to be an accurate version of our charter. And secondly, if I'm mistaken about that, then you have a constitutional issue before you, which purports to ask you to hold that residents of a community, and by the way, state law would require Mr. Moskowitz to be a resident for 1 year before he could be a candidate. That law would be the law of the land in Dewey Beach. So he need only be a resident for 1 year before he could run for office. That law, the complainant's interpretation would require you to hold that law is that minimal criteria is not the law of the land in Dewey Beach, but in fact, you must also be a landowner or have a significant interest in land. That's for residents. There's been some confusion, I believe. There's some references to other ways which you can qualify as a candidate. Those are extensions of rights to non-residents. But the question before you is, what should be, what are the requirements of residents? Because there's no qualified evidence, there's no competent evidence in the record that Mr. Moskowitz is not a resident. So what rules should apply to a resident? And I can tell you the courts have spoken to this issue. Mr. Finger has pointed that out. I have pointed that out to you independently. Secondly, there is this irregularity, which just comes under the heading of only in Dewey, that the state website that publishes our charter seems to have an omission. And I'm very confident of that. And I think it would be inappropriate for us to disregard that and kick the can down the road for the courts on the eve of an election.
May I comment?
No, sir.
Who is that?
So if again, I would ask the members if they have any additional questions or any comments, or if they're ready to engage in their deliberations to resolve this.
Okay, Marty, do you have any questions?
I have one question. Fred, I assume that if a town has Carter. Hold on just a second. If something that is in the charter of the town of Dewey Beach, wouldn't the Constitution under hold on just a second. if Delaware and the laws of the United States, wouldn't they supersede the
Municipal charter?
I guess the charter, yes, and Dewey Beach. Sorry.
So what you're
That's what I'm trying to understand is
right.
how can that be greater than what is
In the Constitution?
of the state of Delaware or in the United States?
Right. So the complaint has asked you to strictly apply the law as expressed in the charter. And unfortunately, we have a debate as to what's in the charter. But setting aside that debate, the complainant is asking you to disregard Delaware case law and U.S. Supreme Court decisions, which recognize that it is a violation of the Equal Protection Clause to require of residents who would desire to run for office that they also be landowners. And I mean, none of the complainants wish to offer any support for the public policy behind this, which is to exclude people. So we think that that was never the intent, or I think it was never the intent in Dewey Beach that residents who don't own land or have a interest in a leasehold be excluded from the right to run for office. And I've offered an explanation for why that is. The original charter contained a clause which clearly allows candidates to run who are full-time residents and domiciliaries of the town without respect to land ownership. It is just a very peculiar circumstance that language has somehow been omitted from a bill that amended the charter in 2012. But your question is asking, do you have the right and obligation to recognize the existence of case law which finds that type of requirement in a charter to be offensive or unenforceable or violative of one's constitutional rights? And I can tell you in the Gebline case, as was referenced by Mr. Finger, that's what the court did. In that case in Frederica, the applicant did not own property. He wished to run for office. He was told he couldn't. And the argument in favor of the requirement of land ownership was that people who don't pay property taxes shouldn't have any control or any say over how revenues from property taxes are allocated in the town. And the court the court dismissed that argument out of hand. I think it's interesting that in Dewey Beach, that argument is not even available to those who would come to that conclusion, because we don't pay, or citizens of Dewey Beach don't pay property taxes. So I hope I'm answering your question. I think it would be dangerous and inappropriate and additionally possibly costly to the town to disregard a known Delaware case and Supreme Court case which interpreted language that cannot be distinguished from this. I think a leasehold interest is an interest in land, an ownership interest, and the fact that ownership requirements or land ownership requirements are slightly different from leasehold requirements. They're all interests in land, and I think they all cannot be imposed upon residents of the town who wish to be candidates for office.
I think Fred misstated my
Is there any other questions, Marty, on your part?
Not yet,
Uh,
maybe.
Kay, I have actually, Kay, do you mind if I go in front of you?
Go ahead.
By the way, Lane, if I can interrupt, you don't have to have a question. You may begin your deliberations whenever you like. You can make your remarks and attempt to deliberate over a motion at any time.
I do have a couple of questions that I just wanted to get clear, but you know what, Kay, I can wait. You give your questions first.
My only question is, he definitely is over 21, so that is yes in his favor. The second thing is he is a bona fide resident and has domiciliary in the town. And I think that's what we're looking at. We're looking at, is he a resident? But this instrument we have from our tool from 2012 adds the other component, the land ownership. The one from 1981 only says a full-time resident and living in the town. So that's the only thing that I have to have in my mind, that we are doing as an election board the correct thing as far as what the charter says. And so I leave that up to my fellow board members to discuss and let me know how we look at this. I'm done. Thank you.
I guess I'd like Fred, because I don't think we can discuss it without legal counsel, because we're not lawyers. But I think Kay clearly stated a couple of the boxes that were ticked. And then there was discussion earlier on about David handing in a lease, which also is another box that seems to be ticked because it was not asked. I think you said something, and this is Fred, where I'd like you to talk a little bit about that to us, because at the time of his application as a resident, he provided the documentation that he did provide. And then when there was a challenge, he provided even additional information that deals with this lease issue. So I would see that remedied any question about if you get away from the constitutionality, that he remedied it by providing us the lease. And then, so I'd like you to kind of guide us in that area, because it's a chilling effect on candidates. And as a board, we should be not participating in that kind of thing. So, but we also want to uphold the law, whether it's the municipality, the state, and I assume our oath says, to the best of our ability, even the US law. So, Fred, could you help us there?
Well, that was a lot. You're asking what we should make of the provision of the lease and how that impacts your deliberations. Is that right?
Well, I'm asking that we know we've ticked off all of these boxes of that he's qualified, and there seems to be the dual concern about upholding the charter, which, what I understand you're saying to us, is unconstitutional, never be upheld in court if we had to go down that path, and we wouldn't go there if they took it to court. And because that's already has a long history in legal cases. Then there's the question of does David have a lease, even though that's not constitutional, and he's even provided that to us. So I'm perplexed about how I want your thoughts on that.
Well, it's confusing again, because if you can be a leaseholder candidate in my view without being a resident of the town. So what the charter does, and what some beach towns do, like Dewey, is that they provide an extension of a right to participate in the political process by saying people who are invested maybe with their second homes should be able to participate in Dewey Beach. But what's being challenged here is the right of someone who's established to be, in my view, a resident of the town. So a leaseholder need not be a resident. He must just simply hold a lease. So that's an extension of the right to participate to somebody who may consider themselves a domicile of the state of Maryland or New York or New Jersey or Pennsylvania. That's what's confusing here, is you have these competing concepts of extending rights to participate in the political process, including to vote. But at the same time, the way the charter is being read by the complainant, unless you own property, regardless of the fact that you're a full-time resident of the town of Dewey, you're not eligible to be a candidate.
Charter defines the resident term.
Please mute Dave Davis, please. I'm sorry, Dave, this isn't a participant.
You're misstating my claim.
I don't believe that I am. So the question here is, has the complainant proven that Mr. Moskowitz is not a resident? Because in my view, the law is, if you're a resident for a year, you are eligible to run. And that's based on two things. That's based on the this missing charter provision, which we just confirmed this morning. And secondly, the existence of case law, which for a very long period of time has said you cannot require property ownership. And I believe a leasehold interest in a 5-year lease or longer is subject to the same consideration of people who reside in a town who wish to run for office. You can't exclude those people. That's what the law is, I believe. And I believe the Chancery Court case and the Supreme Court case established the law here. And I think it would be irresponsible of us to ignore that and make a holding based on a technicality. That's my view of it.
So as far as the board is concerned, again, this is just my asking as not a lawyer, but your opinion, you're going to write an opinion after this? No.
I'm going to write a decision that comports with the motion that this group passes tonight.
Okay. All right.
I'm going to write a notice of decision, and it's required by statute to be issued within 24 hours of your motion.
So one more time, and I'm going to ask the board also, because I've been working on the elections for a while, and I know we're all tired, but clearly state that his residency is not in doubt. And in your opinion, is he a viable candidate based upon even with the technicality, the issue with the owning property in our charter? What is your legal advice to the board?
Well, that's really a question for the board to determine. So I think I've given you my legal advice. I think it's up to the board to make its determination at this point.
Okay. I want to ask Kay, do you have anything else to add?
I think we need to follow our council's recommendations and interpretations, that this would be unconstitutional for us to find that he did not qualify as the resident. I mean, that it would not stand up in a court of law. And even though when I look at the tools they give us, which is the 2012 bill, it doesn't state what the outcome of the court cases were. So that's my only statement. That's what I'm looking at. I want to hear what Marty and you have to say.
Marty?
I also agree. I feel uncomfortable going against the Constitution of Delaware and the United States. And I'm also not very happy at feeling threatened by making a decision. And the three of us have been threatened with, legal action, which I feel uncomfortable about.
Well, Ms. Tarr, I don't think, I'm not sure what you're referring to there. I think I have heard, if you're referring to what was spoken today, what I've heard is that there possibly could be legal action that follows this. It shouldn't be interpreted by you to be a threat to you personally.
But that is the way the individual who spoke during that time certainly made comments that were directed toward the three of us very clearly.
Well, it takes courage to serve on any board in Dewey, that's for sure.
That is the truth.
I do not appreciate, because we are serving in that capacity. We are volunteers. We are asked to make a decision to the best of our ability, and we are being threatened, which makes me very unhappy and uncomfortable by that.
I agree. But would you like to say anything more about?
Perhaps we can ask for a motion. Maybe a motion could be offered, and then we could.
Okay, I'd like to say that I agree with my other board members that I want to follow the advice of the town council. I feel that, again, that I can't add anything to what Kay and Marty has said. I would, as Fred said, a motion, and you will help formulate that, I believe, because the motion to deny or accept the complaint. Do I need to put anything more than that?
No, we need someone to make a motion, and preferably it would be either Kay or Marty. So let's hear let's hear whether we have a motion. And
do you have a motion, Kay or Marty?
I make a motion that we accept David Moskowitz's application as a resident for this election on September 22nd, 2020.
so, Kay,
Yeah.
Ms. Sullivan, if you would, could you formulate that in terms of denying the challenge that's
Sure, I'll be glad to. I make a motion that we deny the challenge from Mr. Davis in regards to Mr. Moskowitz's residency in the town.
or eligibility to be a candidate for elected office.
And his eligibility to be a candidate in the upcoming election.
Is that your motion?
Yes.
Can it be read back?
Can't be read back.
Okay, so I agree with what I understand that.
So,
Okay.
Ms. Bowl, could you ask for a second?
Could I have a second, please?
I second.
Okay, so At this point, I think it would be appropriate to turn to Ms. Sullivan to give her support for her motion, and then Ms. Tar, and then yourself.
Okay. Ms. Sullivan, do you give your support for your motion?
My support is our town council and his expertise in doing the research on this complaint. And this is why I chose to make the motion.
Isn't it just a support? You support it?
Yes.
Yes. Fred, excuse me, Fred. Doesn't he just say, I support it, and then a second? She doesn't need to add any information, correct? Besides what we've already said.
I would ask, I'm asking you to give your support for the motion. And that's not presuming how you all are going to vote, but we have only 3, and we have a motion, and we have a second.
Okay.
So, Ms. Sullivan, you've indicated one grounds for your support for the motion, which is legal advice you've received. Do you have any other support you wish to offer?
No, that's my support.
Okay, do we have a second?
So we have a second. So now we're in the process of voting now. So Ms. Tar, if you would offer your vote and your support on the motion to deny the challenge to Mr. Moskowitz's eligibility to run.
I support, and say it again.
Do you support or deny?
The motion.
I support the motion
And why do you do that?
because of my understanding of the charter and the information that I have read and been presented to me.
Okay. And do I give mine now? I support the motion.
You vote in favor of the motion, and what is your support that you're offering for your vote?
My support is that the fact that it is his. I'm sorry, I thought we kind of went through this already, so it's finding it confusing. I support that the motion that Kay presented in its totality. Okay.
It's whatever it is. It's whatever your
The motion to, for me, I'm going to say accept that motion. I accept it. Her motion.
So, Ms. Ball, at this point, I think it's appropriate for you to declare that the motion has carried
Okay, the motion has carried
and the challenge has been denied.
and the challenge has been denied. Thank you for the assistance. I apologize for the roughness. Okay, I have take a motion to adjourn.
I make a motion, we adjourn this hearing.
I second the motion to adjourn.
Okay, all in favor, say aye.
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 Okay, aye, thanks. Okay, is that it, Fred?
Yep, we're adjourned. Thank you.
Aye, adjourned.